Just about every country has a protective constitution that establishes the rights for its citizens. Most Canadians assume that the Canadian Charter of Rights and Freedoms protects Canadians in the same manner that the U.S. Constitution protects Americans. But what if that assumption is wrong? What if Canada's constitutional framework, despite invoking the supremacy of God and the rule of law, actually gives the government the final say on your freedoms, while the U.S. Constitution gives Americans the final say on government power? Today we're going to compare these two documents side by side, from their philosophical roots in natural law to their legal mechanisms and court cases, and see why one system enshrines objective limits on power, while the other relies on subjective interpretations of reasonableness. So the U.S. Constitution starts with the premise of limited government. Article 1, Section 8 enumerates the specific powers granted to Congress: taxation, defense, commerce, and currency. And the 10th Amendment completes this circle. The powers not delegated to the United States by its Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. That is an objective structure, a list of what the government can do, and by exclusion what it cannot. By contrast, the Canadian Charter of Rights and Freedoms, established in 1982, begins with a philosophical flourish in its preamble. Canada is founded upon principles that recognize the supremacy of God and the rule of law. But right after this inspiring statement comes Section 1, the fine print. The Canadian Charter of Rights and Freedoms guarantees rights and freedoms set out in it, subject only to reasonable limits prescribed by law, as can be demonstrably justified in a free and democratic society. That clause, subject to reasonable limits, changes everything. It means that every right is conditional, balanced, and open to judicial discretion through what's known as the Oakes test. In R versus Oakes, the Supreme Court of Canada upheld a framework for testing whether a law that limits the Charter can be justified. To survive scrutiny, the government must prove 4 things. Number 1, a pressing and substantial objective. Number 2, a rational connection between the law and that objective. Number 3, minimal impairment of that law. And number 4, proportionality between the benefits of the law and the infringement on freedom. Now that may sound rigorous until you realize that the courts defer to governments in complex policy areas or during a crisis. During the pandemic, for example, the courts upheld sweeping restrictions on mobility and assembly under Section 1's Reasonable Limits Clause. Compare this to the United States, where the First Amendment flatly states, "Congress shall make no law abridging the freedom of speech or the press, or for the right of the people to peacefully assemble." That's not a balancing test or reasonability test. That's a prohibition. And when the government in the U.S. oversteps, the courts can strike it down without even asking whether the law was reasonable. The contrast between Oakes and Marbury and Madison in 1803 captures this divide perfectly. The Oakes test empowers the government within reason, but the Marbury case limits the government by principle. But in Canada, even if a law fails the Oakes test, there is another escape hatch, Section 33, the Notwithstanding Clause. Parliament, or any provincial legislation, can declare a law to operate notwithstanding Sections 2 and Sections 7 to 15 of the Charter, meaning that they can override expressions of free speech, assembly, and equality for up to 5 years and renewable indefinitely. This clause has been used extensively in Quebec, restricting English signage and public sector religious symbols. In the United States, by contrast, no such override even exists. Once the Supreme Court rules a law unconstitutional, that's the end of the story unless the people change the Constitution. And that speaks to the major difference between parliamentary supremacy and constitutional supremacy. In respect of parliamentary supremacy, beyond the Charter, the Canadian legal framework gives the government even more power, specifically under Section 91 of the BNA Act. And even going beyond the Charter in this parliamentary supremacy idea, the Canadian government has even more power extending beyond the Charter. We can refer to Section 91 of the Constitution Act of 1867. It shall be lawful for the Queen to make laws on peace, order, and good government. Now, this is commonly referred to as the POGG rule or clause. And it's been often interpreted by the courts to expand the powers of the government in areas of national concern or during a crisis. In the 1976 Reference Re Anti-Inflation Act, the Supreme Court of Canada upheld the federal government's price and wage controls, and that was deemed as a valid measure under the POGG. The result is that Canada's constitutional limits on federal power are bendable. In the US, however, powers that are not specifically delegated remain with the states. And when the federal government overreaches, the courts often strike it down. Now, one such case was United States versus Lopez in 1995, which limited the use of the commercial clause to justify federal control over local matters. Canada's legal tradition also tolerates broad delegation to the executive. In the 1918 Supreme Court decision in Gray, the court upheld the federal government's delegation of legislative authority to the governor in council during the wartime period, effectively allowing the executive to legislate by regulation. Later, in the October crisis of 1970, Pierre Elliott Trudeau invoked the War Measures Act, suspending civil liberties nationwide. Now, although that act was replaced in 1988 by the Emergencies Act, the precedent remains. Canadian courts are historically comfortable with wide executive powers during a crisis. And by contrast, in the United States, even during times of war or emergencies, the courts have traditionally pushed back. Notably, in Youngstown Sheet Tube versus Sawyer, where in 1952 the Supreme Court of the United States struck down President Truman, who was trying to seize private steel mills during the Korean War. But perhaps the greatest omission in the Canadian constitutional framework is the absence of absolute property rights. The earlier Canadian Bill of Rights from 1960, the Prime Minister John Diefenbaker, the right of the individual to life, liberty, and security, who protected the right of the individual to life, liberty, and security of the person, and the enjoyment of property. But the Bill of Rights is an ordinary statute. It's not bound in legislation, and therefore not bound to the provinces to respect. In the Charter Section 7, guaranteeing life, liberty, and the security of the person, this has been interpreted narrowly. In Irwin, Toy, and Gosselin, two cases before the Supreme Court, the court explicitly rejected the notion of economic liberty as part of the Section 7 rights. By contrast, the U.S. 5th and 14th Amendments both protect against deprivation of life, liberty, and property without the due process of law. By contrast, the U.S. 4th and 15th Amendments both protect life, liberty, and property without the due process of law. And the Takings Clause outright forbids government from seizing property without proper compensation. From a classical liberal or Austrian economic perspective, this difference is profound. In Canada, property rights exist by permission, and the US, they exist by right. So the Charter's preamble that Canada is founded on the supremacy of God and the rule of law is often cited rhetorically, but it carries no enforceable effect. In Reference Re Succession of Quebec in 1988, the Supreme Court acknowledged the preamble as interpretive context, but declined to treat it as a source of binding rights. Now, by contrast, the American Declaration of Independence and the Constitution itself derive authority explicitly from natural law and the consent of the governed. This is a metaphysical claim that rights precede the state. So when we start wrapping things all together, things like the Reasonable Limits Clause, the POGG, and the absence of property rights, make the Canadian system one of conditional liberty, not inherent liberty. Rights in Canada are granted and then balanced, whereas rights in the US are recognized and protected. That's the philosophical divide here. The difference between positive rights, what the government will allow you to do, and negative rights, what the government is not allowed to do. In short, the US Constitution is objective and limits the power of the government, whereas the Canadian Charter is subjective. It defines limits that can be negotiated. The US founders rooted their Constitution in natural law. They believed that rights existed prior to government because they flow from the nature of man and reason itself. And that's why the Bill of Rights reads as a prohibition on government, not permissions for citizens. The Canadian Charter, by contrast, draws from the post-war European tradition of human rights positivism, the idea that governments grant and define rights to promote collective well-being. Both use the language of liberty, but only one was designed to restrain the government from overstepping its bounds. So when Canadians say that we have rights, what they're really saying is that we have rights until government decides otherwise. And when Americans say we have rights, what they really mean is that they have rights and government better stay out of the way. Both countries are democratic, and both countries are rooted in common law. But only one constitutional tradition was designed to chain the government, where the other was designed to chain the citizen. That's the difference between a constitution with objective limits and a charter of subjective permissions. If you found this video to be helpful in your discovery of politics, economics, financial literacy, history, and philosophy, make sure you like, subscribe, and hit that notification bell, and we'll see you again.